Good afternoon, everybody. I hope I am audible enough. A very warm welcome on a World Data Privacy Day to all of you. So, this World Data Privacy Day is day meant for us to understand that privacy just isn't a checkbox. It's not just a footer link or it's not just a policy document for organizations anymore. It is actually trust in action. And we all know, right, that when the trust is broken, it is far more expensive for us than any compliance program. This is also the time when India has introduced the Digital Personal Data Protection Act, which is the DPDP Act, as we all popularly know. And this isn't just about how the organizations are going to it just isn't about complying, but it is more about putting things into action. It is about upgrading privacy from good old practice, just from something good to do about your organization to actually make it a legal obligation for your organization. This isn't just a law, it's a reset of how organizations are going to collect, use, respect personal data across all their functions, be it HR, IT, sales, operations. I mean, there is so much data that's coming in from all different functions at every organization, right? And today's session is not just going to be about the legal theory. Both our experts present today are going to give you a complete insight into how this law actually what it means for your organization, where organizations are most exposed right now, and how to move from just a reactive compliance, because yeah, right, the DPDP Act is here to actually being a more data, much maturely handling the data governance of it. And this all without slowing your growth or your customers' experience. So, on the World Data Privacy Day, let's move beyond from awareness to action and let's turn compliance into credibility. Today, joining us are two very noted speakers with us. That's next slide, please. So we have joining in today speaker Narsimin Ilangovan. He is an expert cybersecurity practitioner. He is also a co-founder at Incorp Advisory. He has over 15 years of experience as a cybersecurity auditor, author, and keynote speakers at various national international forums. He's been recognized among the top 10 influential consulting leaders in 2020, has led global engagements in cybersecurity audits, and has addressed 5,000 plus national and international audiences, including multiple conferences worldwide. So, with him, we will also be having today as our guest speaker a senior law practitioner, Parth Sarthija. He is from economic laws practice. He has around 15 years of experience in competition and international trade, advises on competition, trade, data protection, and technology regulations. He is dual qualified in India and New York with Harvard, and he's been recognized by leading legal directors, active speaker, and he is also a co-chair at FICCI Committee on Foreign Trade. So as we begin today's session, I will hand over, Nara can take over the session and he can address the new act, help us understand this better, and then we can begin the session now. Thank you, Nara. Over
Sure.
to
Thank you
you.
so much, Dolly. Hopefully, my screen is visible. So, as Dolly rightfully put it, a day to celebrate privacy. And that's where Jan 28th stands at, right? Especially after a lot of years, if you noticed, it has predominantly been focusing on the security framework, or focusing predominantly on how are we trying to protect the data, how are we trying to protect information, encryption, and a lot of conversations as in the last couple of decades have been going on. But in the last probably 4 to 5 years, I see one major transition from security. It is moving towards privacy. So I thought first let me clarify the myth between security and privacy. Because when you go and ask any person in the organization, what is privacy? They will say keeping the data safe. Mind you, that is not privacy, that is confidentiality. So the terminologies are very different. And the confidentiality is a principle which you follow in the security. So those who are from a technical context, you would typically say security is confidentiality, integrity, availability, all of those. To me, in a layman's language, security is ensuring no unauthorized access, breach, disclosure, whatever it could be. But then comes what is privacy. Privacy goes only on personal data. So if I have a trade secret, right, it is confidential, but it is not a personal data. So therefore, the principles of privacy would not be applicable there. You might still want to protect a trade secret, just like how you protect your personal information. That is the security element, right? But the privacy element gets triggered if and only if personal data exists. And I'm sure all of us agree, every organization deals with personal data, right? Now, this personal data could be of different types. It could be name, email ID, phone number, contact numbers. It could go into advanced things like website cookies. Netflix browsing history is also personal data, because the recommendation which I get is not what probably Dolly would get or Parth would get. As a matter of fact, any of you would get, right? So the privacy landscape is very, very different, right? And it is predominantly focused on personal data. Now that you've got clarity on security and privacy, then comes the element of protection, the data protection. This focuses on both these elements. And that's why the beautiful definition, as far as this act is concerned, Digital Personal Data Protection Act, right? We call this as the privacy framework in India. And this for the first time has come through after a lot of interesting challenges which we have seen. Now, why are we speaking so much about it, and why should organizations seriously be worried? So, the November of 2025, 13th November to be very specific, they notified that this act shall be enforced on a deferred basis. So they notified a few sections, which is basically the provisions relating to definitions, certain constitutional powers, and the data protection board was set up. This happened on the 13th of November 2025, right? The law at least came into force. Now they're of course going to have the DPB set up and few more things, which Parth would be covering a little later. 13th November 2026, that is 1 year from the date of the rules being notified, the registration requirements for consent managers, the power of board to ask certain things from consent managers, all of those are going to be notified, or rather, it's going to be applicable. And then comes the biggest thing, 13th May 2027, which was 18 months from the original window, which is probably, if you ask me, a little more than 15 months as of today, right? Is where the law is going to be applicable for each and every entity. If you ask me, just like we say the Companies Act applies only for companies, but the Income Tax Act applies for everybody who's earning an income. Likewise, the Data Privacy Law or the Digital Data Protection Act 2023 is applicable for every organization who collects or processes personal information. And remember, even if I am touching by any means the personal data, it could be a physical, that is, I'm having a view access, or if I'm trying to download, process, modify, any means is considered within the meaning of processing, and therefore this act becomes applicable, and thereafterwards it is continuous compliance, right? So hopefully you've got an idea. And mind you, let me also clarify, not that we did not have a privacy law in the past, we did not have a structured privacy law. We did have the Information Technology Act, and we did have the sensitive personal data rules, but those formed as a quasi or a semi privacy law because it did not have a lot of enforcement directives, whereas now we have a full fledged structure. The most important question which people keep on asking me every time, the DPDP law is applicable only for companies which are established in India? The answer is no. It is obviously if you're in India because you're collecting and processing the data. It is also applicable for global companies if they are relating to services or goods which are offered in India. Hypothetically, let's say there is a social media platform which is not registered in India but has a lot of personal or a lot of users who are based out of India. it would mean that, I repeat, it would mean that for that social media company, which is even though not registered in India, the DPDP Act is going to be applicable because it is offering goods or services in relation to the data principles in India. And data principles are nothing but whose our personal data you're processing. Of course, there are some exceptions for domestic use or if data is made publicly available, those are secondary. But this is the first and foremost point which you should keep in mind. The second thing which you should keep in mind are who are the key players in this entire ecosystem. The principal or the person whose personal data you are processing is called as the data principal. It is that individual. Remember, an organization cannot be a data principal. It is only an individual. An organization's employee can become a data principal. I hope the point is very clear. It's an individual, right? Whose personal data you're processing. Now, whosoever personal data you're processing, assuming it is a child, and we know under the Indian contract law, a child typically until the age of 18 or 21, as the case may be, will not have the right for entering into contracts, right? So the law over here has said, in case of a child who is less than 18 years, the parent or the guardian becomes the data principal, and the parent or the guardian shall enforce. I'm sure for all of our kids, when they go for a hospital checkup or maybe a school takes them for let's say a picnic, as a parent we have to give them consent. So there's going to be slightly similar lines. And in case of a person with a disability, again the guardian becomes the principal. The biggest or the crux is the definition of data fiduciary. Now, data fiduciary is a person, entity, organization by whatever form called, right? But that person or that organization decides two things: means and purpose. In other words, why am I collecting this data and what is the purpose for which I'm collecting? He or she who decides that, or the organization who decides that, would be called as a data fiduciary. There's a variation of a data fiduciary, which I'll address it in a few minutes from now. But data fiduciary are those who actually control, decide how it is to be done. And then you have your processor. Most of us today use SaaS applications. We host data in payroll softwares. We use some, Gmails to your Outlook, to your Zohos, right? All of these things are processing the data based on your instruction. So any entity which processes the data on behalf of the fiduciary is a processor. Remember, the obligation of law is always between the principal and fiduciary, whereas the law casts an obligation on the fiduciary to ensure the processor is also adhering to the principles. So, right, there's a big difference there. And then comes the definition of consent manager. Consent manager is basically an entity who acts like a single point for ensuring data principles are able to give consent, right? To me, it is like a person or an authority similar to that of a KYC registration, but just that this person will manage the consent on behalf of various people. So they're going to be having entity or a tech platform which is basically set up, and the registrations is going to probably take place in next few months. So this, at this point in time, consent managers, we don't have anybody officially notified. We are going to expect that. So hopefully these four terminologies gave you clarity. And also let me compare and contrast with the global regulations. In global regulations, data principal is also called as a data subject. Fiduciary is the controller. This is the most popular word. And of course, consent manager is a concept which they have introduced in India. Rest of the world probably at this point, and as I speak, it is not something which is very popular, right? So hopefully you got that bit of a the definitions in clear. So I thought next we should understand what is the context and what is the purpose of law, or why on earth did they come up with this, and how do I get started, or what is the overall objective, right? So I would invite our guest speaker, Partha Sardi. Parth, if you could quickly take this and explain to our audience on the context and purpose of law, and from there.
Thanks, Nara. Thank you, and thanks, Dolly, for organizing this. Good afternoon, everyone. So, I'll just be taking this section on context and purpose, and in that context, I will also explain the key concepts, which is consent and legitimate use-based processing. So, let's first understand the context. The context is there are a variety of factors that why this law has come in. One important key factor is that as we are entering into Industry 4.0, which is more a digital-based economy, right? The data becomes a key to this, right? So there is there was an urgent requirement that the data collection practices and data processing practices by companies need to be addressed. The immediate context for India, of course, was Puttaswamy judgment, where the Supreme Court 9 judge bench held that privacy is a fundamental right, and this law is in some parts, of course, trying to implement that law. Of course, arguably there are defaults in this law as well when we put it against the Puttaswamy test, but we are not getting into all of that. The broader context is, of course, global. EU GDPR law has been a pioneering North Star for many jurisdictions on data privacy law. And to that extent, Brussels effect is indeed very much happening in front of our eyes. More and more countries are adopting data protection laws similar to either GDPR or some variant of that. Now, let's understand what's happening in the Indian context. Nara very nicely detailed out the whole requirement in terms of timelines which you need to meet, who are the key stakeholders. But here are the key fundamentals and he also spoke about applicability of law. Now, if you look at the data protection law, personal data protection law, DPDP Act, two things which is very important is, number one, it applies only to personal data, and personal data has been defined, and it is information through which an individual can be identified at a very broad level, and it may include many things. Unlike GDPR law, the definition here is very small. The previous iterations had a definition which was more aligned with GDPR law, but essentially it means that any information on a standalone basis or in conjunction with some other information, if that can lead to identification of an individual, we're talking about natural person, then that's personal data. Now, personal data in itself doesn't trigger anything. The personal data, which is in digital format, that's where the DPDP law comes into picture. So if you are sharing data or collecting data in non-digitized form, the DPDP law doesn't apply to you. But if you collect something in non-digital form and subsequently digitize it, then that's that's where the trigger happens. And how does it happen? If you are engaged in any processing of digital personal data, the DPDP Act will apply to you, as explained by Nara in the opening slides, that when it happens, when it is in India, when it is in outside India, there is an extraterritorial element to this. And processing itself as a concept is a very wide concept. All kinds of operations of data, right? Whether it is collecting, storing, indexing, sharing, everything is called processing. So the moment you collect somebody's digital personal data or personal data in digital form, you are already in the process of or in the activity of processing of digital personal data. Now, you cannot process digital personal data under this law unless you meet one of these two requirements. Either it has to be based on the consent of the relevant person, in this case, as Nara explained, data principal, or it has to be based on legitimate use. Now, I'll explain both these concepts. Maybe we can move to the next slide. What is consent-based processing? So consent-based processing is nothing but essentially you need to take consent from the data principals through a notice. And that notice must have an itemized set of personal data information which you collect. It has to have a specific purpose, that why you're collecting that data. And only then, after that, if a data principal has given a consent, and that consent has to be free, specific, unambiguous. All of this means that you can't have indirect consent. You can't say to someone that I have issued you notice. If I don't hear a response from you, I take it granted that you have given me consent. No, the consent has to be very active consent. And only then you can process data if your processing is based on consent. There is a case for non-consent based processing as well, but I'll come to that. And you cannot do excessive data collection either. Part of the law, when we talk about context and purpose, is also to encourage companies to do what we call data minimization. So if you see on example on the screen, this is flowing from the act itself. If you're buying a medicine from a medicine shop, let's say a pharmacy shop, right? And they need your let's say, name or mobile number so that they can send you a bill. But they also ask you for your contact list, right? And even if you give consent to that contact list, the law is going to sever that consent, because for providing you with your medicine or drugs from a pharmacy, so they did not need your contact list, right? So that consent which they have obtained, even if they obtained from you, law will not treat it because it's not related to the product or service which they are offering. And that consent will be severed, it will be invalid consent. And to that extent, that collection itself then is in violation because it is without consent. So that's the rigor of how the consent has to be taken, particularly for data fiduciaries. So you have to be very careful on what kind of information you are collecting and why you are collecting. The next is the elements of the notice itself. So like I said, it has to have an itemized description of the personal information or personal data which you're collecting, a specific purpose, why that information is necessary, what is that purpose for which you're going to process that data. Other than that, in that notice, you also need to give certain other information. One is about how can somebody withdraw consent. So you need to provide a link to your app or website wherever there is a withdrawal of consent mechanism in place. You need to give a link to that. You also need to tell the data principal about exercise of certain rights, and that is about how to approach a grievance redressal mechanism in your company. In addition to that, you also need to tell them that what can they do, how can they make a complaint to the board, and I'll come to the board in subsequent section. So these are the elements of the notice. Second is the notice itself has to be in a plain, unambiguous language. You cannot frame your notice in a manner that it is cumbersome or it is linked to 5 different documents, so that a data principal needs to go through each of these links and read 5 other documents. It has to be very plain language notice, which is very comprehensive and easily consumable by an average, a layman on the road. The fourth item is that you also need to take care of the language issue. So not every data principal may be conversant with English, let's say, and somebody who is speaking in a vernacular language, let's say Bengali or Telugu, right? You need to give them the option to read the notice and give their consent in that language. So the language has to be any one of those which are identified in Schedule 8 of the Indian Constitution. And then this consent has to be taken either prior to processing of data or collecting of data, or at the time of it. So it has to be done. It can't you do later. The second point is also about legacy data. So when the act comes in force, so May 2027 current deadline, if that's the time when the act comes in full force, any data, personal data which you have collected prior to that, which we call legacy data, for that also you'll have to issue a notice. In this case, you are not seeking a consent, but you're issuing a notice just to put them on notice that I had collected this data from you. Here is the notice for that. And you again need to give an option to withdraw consent for that data. If somebody withdraws, then of course you'll have to stop processing. If no one withdraws, then you have that data. You can process the data because you have given notice for the legacy data. When you don't give notice for the legacy data, you are again in violation and in breach of the law. The second aspect of processing is, now if you can move on to the next slide, is legitimate use-based processing. So like I said, processing, which is collection, storage, anything to do with any operation to do with personal data, can be only on 2 grounds. So one I just discussed is it has to be consent-based. And if it is not consent-based, it must fall into one of the identified legitimate use situations under the law. Legitimate use is nothing, but law has identified certain specific purposes for which data, personal data of data principals can be processed without their consent. The easiest example I will give you from your context, if you are a company, if you have employees, you don't need consent from your employee to process their personal data. So for example, if you have employees, of course you'll need their names, mobile numbers, telephone numbers, addresses. In some cases you might need their details about their family, maybe their dependent children, spouse, parents, and all of that, because you want to provide them some with additional benefits. Could be, let's say, medical insurance claims, all of that. So you can process all of this data, you can collect all of this data without specific consent, the way I just explained a few minutes back, because law recognizes that data can be processed for certain legitimate use. One example is employment. Second example could be quickly if you're processing someone under a medical emergency, right? If you're processing somebody's data because there is a medical emergency at this point in time, you cannot follow the processes of consent, notice, etc. You are able to demonstrate there was a life-threatening event, and you are, let's say, collecting somebody's health record and processing it. That is something law has allowed it. There are 7 different items which are classified or qualified as legitimate use. If you fall under that, then you can do it without consent. But what companies need to be careful about is that the legitimate use based processing has to fall within the 4 corners of law, and you cannot stretch it so wide that it violates the spirit of the law or objective of the law, because the legitimate use exception, as far as notice is concerned, is likely to be interpreted narrowly by the courts because of Puttaswamy judgment. Puttaswamy judgment puts threefold test, and those threefold tests will apply here as well. So these are the 2 things. Any processing of digital personal data, if you are engaged in, the DPDP law will apply to you. And if it applies, then that means that you cannot do processing either without consent or it has to be based on a legitimate use. I'll just pause here and I'll request Nara to go ahead with other aspects of the law.
Thanks, Parth, for giving that perspective on when and what circumstances you can process personal data. The next thing which is very important is for you as an organization, how do you prove or how do you say that you are data privacy compliant or you are DPDP ready or have I started my journey? And this is where first and foremost you need to recognize that organizations or entities and establishments, it could be even a single person, collecting personal data is called as a data fiduciary, and such data fiduciaries are typically to whom most of these obligations actually fall. And we have already understood that fairly by now that literally everybody who's using personal data will fall under the definition of data fiduciary. So it's not based on size, it's not based on where you're located, it is not based on am I a startup or a large establishment. Everybody, this basically applies. So within that, they've also defined what is called as an SDF, significant data fiduciary. Typically, these are stakeholders where stakes are very high. Okay. So in simple language, the government has not defined that these are the entities who are SDF, but rather has said the criteria where the government may notify. While we speak, we have not had any sort of a formal notification on this yet. However, what is the point which you should keep in mind is that these SDFs are decided based on the volume and sensitivity of data. What is the potential risk to the data principles or the rights? And what could there be a possible impact on the sovereignty and integrity of India? So these could be factors which are considered by the government. Now, all of these SDFs should have at least 3 things in addition to what the rest of them do. A, you need to have a data protection officer and he or she has to be a resident in India, right? First. Second, you need to perform an independent data audit by an data auditor. Again, who they have not notified who a data auditor is, we'll have to wait for the clarification. And third is very important, conduct periodically data protection impact assessments, also called as DPIAs. And these are sort of risk assessments which are performed by the SDF so that they understand how the personal data is being used, how the personal data has possibly, am I continuing to ensure throughout the life cycle of personal data, am I following these terminologies or these requirements, right? Now, one must be thinking that, hey, if I have these three and, if I have this SDF sort of, who would possibly fall under this definition, right? Who are the people who can look into, right? So we just brainstormed, we just thought we'll give you some examples or illustrations of who could likely fall under this definition. Let me clarify, as we speak, we don't have an authentic source to say, hey, this is what or this is how it is, right? So we're talking about large social media platforms. We're talking about e-commerce companies. Along with telcos, right? Financial institutions, your BFSI, healthcare platforms, government agencies, cloud service providers, payment aggregators. Now, these could likely fall under this because they're dealing with large volume of data. Now, please bear in mind, we still have to wait for the clarification as far as the government is concerned on who would fall within SDF, but nothing wrong in probably being ready. And let me also give you another heads up. Last week, the ministry sort of wanted to say that we are preponing, or we are taking the timeline for implementation of DPDP 6 months ahead, not a deferment, it's rather pushing it ahead, pushing the line ahead. And this, they said, for certain large companies, including social media, SDFs, banking, etc., so that they can be ready much in advance and their implementation challenges can be addressed. But as we speak, we still have not got clarity whether this is going to be enforced. So you'll have to be a little patient on that. So SDF will have to have an overall accountability. I mean, in general, data fiduciary is responsible for how the data is processed. So the accountability. Second is security safeguards. How are the security principles? In fact, I have a follow-up slide on that. Accuracy and consistency. Please bear in mind, it is not that I will follow the privacy principles at the time of which I'm collecting the data. It is throughout the life cycle, right? For example, I've collected the data through a valid consent. How am I safeguarding? How am I securing? How am I reaching out to him or her? Am I using the personal data only for the intended purpose? And if that person has opted out, have I deleted, purged it? Am I able to move this personal data throughout the value chain, including my contractors, subcontractors, their contractors? So the list, in fact, increases significantly, right? So it's all about that element. And of course, purpose limitation and erasure, which we spoke of, restrict only to what is necessary, don't collect every possible data. Now, as an organization, we always say that, security first, do not do certain things, we are focused on protecting the user's interest, which is all fair. But what is also important is to understand the privacy law also insists certain security measures, right? And these are illustrative, which are inferences drawn from the rules. While I would not say that every element is mentioned specifically in the rules, but this is eventually a good interpretation and a good set of guidance, right? First, security measures, encryption, obfuscation of, or what is also called as masking of sensitive data. These are all a few examples of um, or methods which you can look into. And we always have the popular access controls restricting the access of personal data only to relevant people, stakeholders. So one could imagine if my CRM or my payroll software was indicating this person's name, Aadhaar, mobile number, etc. Now I may want to be very cautious. Only name I want to display. I don't want to display Aadhaar number. I don't want to display mobile phone number, right? Unless there is a reason for me to modify. And that's basically what we talk about technical measures, right? And there is a mandatory requirement for a logs to be maintained at least for a year. And this is required if there has been unauthorized access, audit trails are required, real-time alerts are required. So all of these things are monitoring space. And then comes the business continuity and disaster recovery, right? So here we're talking about backups, because unfortunately, if there is a breach, right, now your data subject is not able to access his or her data, now it becomes a larger problem. Then from a processor perspective, there are certain additional requirements, right? A written contract with the processor is necessary. You need to have, as I said, the outsourcing arrangements. You typically need to have data processing agreements and addendums. So all of these things are necessary to ensure that the processor, which is nothing but your contractor, subcontractor, etc., are having the required security measures, and make sure that you mandatory have a right to audit clause and your data protection liability, because the breach by the processor could make the fiduciary responsible. In other words, you are outsourced the work to somebody else. It is remember that you may have given them the work, but you are still accountable for this entire mishaps, if in an unfortunate event, if something happens. And also, not just this, you also have to make sure that you have good amount of employee awareness training, incident response procedures, having security policies defined. So all of these things becomes a sort of a package requirements as to what you should achieve. So now that you've got clarity on the elements of security, we should also look into how this law is going to be enforced and who is the enforcing authority. So if I would request Path to quickly touch upon the Data Protection Board and probably the related compliance.
Sure. Thanks, Nara. So, like all other, you know, special statute, I would say. So you have one more sheriff in town now, and that is Data Protection Board of India. This board, or DPPI, will be responsible for enforcing the personal data protection law. Of course, there are appeal mechanisms and all, which goes to TDSAT and then to Supreme Court. But this is the primary body. This will be again kind of a regulator which looks at the data privacy or personal data protection aspects across all sectors. It's not specific to any specific sector. It is sector agnostic. The entirety of the data protection law will be enforced by this board. Now, the government has notified the establishment of this board with 4 members. Members are still to be appointed. Uh, there is a requirement that there will be one member, which has to be at least one member from legal background. Of course, as you know, there have been history of cases with respect to regulatory bodies and their appointments of chairpersons and members and all of that. And I think the government has been cautious by telling that there will be at least one member from a legal background. What is curious, though, is that quorum requirement is 1/3 of the membership. And currently it will be 2, but the quorum requirement doesn't really specify that quorum will suffice without, I mean, has to be with one legal member, and that could be problematic. Now, the board is going to function as a digital office, which is nothing but paperless board, and it will have power to do many things. So if we go to the next slide, Nara, uh, so one, the board has powers of civil court for certain aspects where it can take evidence, issue summons, and all of that. And of course, it has power to issue directions on and ask companies to modify their business practices so that it is in compliance with law. It also has power to penalize for certain offenses or, let's say, non-compliance or breaches of the law. I'll come to that separately. It also can accept voluntary undertakings. So, if a company proposes certain commitments, undertakings in order to make its business practice compliant with the law, and the board can accept those compliances. For repeat offenders, and repeat violations of law, the board also have power to recommend to central government to block the business completely, and that is going to have a very huge, significance and impact for businesses. Now, in terms of penalties, if you go to the next slide, uh, the data protection law not only will, I mean, breaches will not only cause you reputational damage, but it will also cause you monetary damage in the sense that the penalties are quite high. It may range from 50 crores to 250 crores, that is roughly around 2.5 billion INR we are talking about, depending upon the nature of the violation, right? So, for example, if there is a personal data breach, and I'll come to that, the penalties can go up to 250 crores. It is slightly different from GDPR law, where the penalties are based on turnover. Here, the penalties are flat. There is a specific amount which has been prescribed, and you can go up to that amount. Now, specifically talking about personal data breach, because that's important, maybe we can move to next slide. Uh, Personal data breach is any unauthorized disclosure of personal data that essentially compromises confidentiality, integrity, or availability of that data itself. And as Nara explained, as a DF or data fiduciary, you must take appropriate suitable measures, which is technical and organizational measures, and you should put that in place so that you can avoid personal data breach events. Now, personal data breach event can happen for n number of reasons, but if you have failed to take reasonable steps as provided in the law, then you would be responsible for that. And if there is a breach, then you need to immediately notify to data principals about the nature of the breach, what kind of data has been leaked or got disclosed, or there has been a let's say cyber attack, whatever the case may be. What is the nature of the personal data which has been breached? You need to provide that. You also need to tell them what is the mitigation measures you immediately adopted, all of that, and what is the impact of that on that data principle. And within 72 hours, you also need to submit a report to the board with similar information, giving them complete details of the circumstances in which breach happened, what were the facts, what are the measures which you have taken after the breach to mitigate the damage, and all of that has to be reported to the board as well. So these are the obligations on data fiduciary across all industry sectors. And like I said, and the Data Protection Board, of course, also has power to adjudicate on claims by data principals or anyone who is an aggrieved party. So I mean, in the sense that whose personal data has been breached. So I'll just pause here and then I'll request Nara to come to the final slides and then we'll take questions.
Thanks, Path, for giving that implementation and the governance structure in place. So, what are we telling our stakeholders, our audience, and our clientele? What is our call to action? First and foremost is to recognize the fact that each and every of you, each and every one of us are data fiduciaries because we would be processing personal data. So now for this, the first obligation or the way we should look into it is see what the lawful foundation of you processing personal data is, right? It's either based on consent or based on legitimate use, which Parth explained. Second, empower the users and the systems, right? It could be a system which is designed to be privacy compliant, it would be awareness, it could be being making sure that the data principals are aware of their rights, and making sure your organization systems and colleagues are aware of the privacy principles. And then comes robust security measures. Now these robust security measures could be something to do with how are you safeguarding your data, how are you protecting it, your obfuscation to your anonymization, can I do something called as a pseudonymization? And there are so many privacy enhancing technologies today, we call it as pets. So how do I build that security element? And then comes the element of accountability, right? Whom do I hold them accountable? What are your obligations? Are you able to demonstrate compliance? And that becomes your typical readiness tool, right? And this is how organizations will mature. And it is not a single step, it is a series of exercise, which is what is to be done, right? So typically, we've been advising clients, and this is where we want to give you a heads up as well, that bring in your gap assessments by reviewing your existing policy and structure, and that's where we come in very bring our value addition. Implement what are your recommendations. It could be policies, documents, it could be process flows, it could be technology related. And then you need to showcase continuous set of engagements and moving further, and that's typically how you would be able to mature in this journey, right? So hopefully this gave you some thoughts and ideas on how this works. And I would request if Parth, if you can also share some of your call to action and your concluding remarks before we take up some question and answers.
Sure, Nara, thank you. I think this is very nicely summarized. The only point which I'll make is that what we have heard in engagements with our number one, which Nara also alluded to during his intervention, is that number one, the deadline of 27th May 2027 can be advanced. Already for big tech, there is a talk that they can advance it. And previous to that, also, IT Minister had alluded that he may consider advancing it. So, number one, please don't think that May 2027 is the time around when we'll start doing this, because this is a process which will take you some time, depending upon the nature of your organization size, etc., the nature of personal information and volume which you collect. So it's better to start early. Number two, what I have heard a lot of times is that people do say sometimes, particularly companies who are based in Europe as well, that we are GDPR compliant, so therefore there is nothing to worry about. But there are elements of DPDP law, even though it is in many ways inspired by GDPR law, which is a GDPR plus. Simply that concept is not, for example, consent managed is simply not there in GDPR. For example, issuing notices in 8 different all languages which are identified in Schedule 8 of Indian Constitution is not under the GDPR. There are elements under the Indian DPDP law, which is a GDPR plus. And for a complete compliance of this law, you'll have to comply with the Indian data protection law. So I just wanted to add that I think Nara has very beautifully summarized the steps which you need from gap assessment to implementation and post-implementation support as well. But at this point, I don't have anything further to add, and maybe we can conclude here, Nara.
Thanks for that. And Dolly, if I could request you to take it up. I see some questions coming in there. So let me see if we could take it. Sarika says, would airlines be treated as an SDF? Uh, Maybe some airlines, after the recent struggle of cancellations and other things, are we going to treat them? So I think, as I said, the law is as of now not codified to say these are SDFs, right? It depends on the amount of data they are processing. To me, it is a thin line. It could fall under either of the sides. So the best case could be that treat them as an SDF and start going, because I mean either ways they're a DF, right? It's only the three additional obligations they would have, which is your data audit, annual assessment of some elements, and having a DPO, right? So treat that as they are an SDF and get going. Nothing is going to change the world.
I would completely agree with you, Nara and Sarika. I think there is some talk about who can be SDF based on the media reporting right now. Big techs will be SDF. As Nara said, that I think airlines will fall somewhere on the borderline right now. But I'm fully aligned with Nara. Like, it's good to go ahead and treat yourself as SDF and do the compliance, because the delta between DF and SDF is only about DPO and few other items which Nara said. So I think I am fully aligned with Nara.
Sure. Thanks. So there's another question. Do fiduciaries need to rely on registered consent managers to handle consent notice, or they're required to invest in building or using their own consent management platform? Parth, you want to handle this?
Yeah, so again, I think it's not very clear from the law that you must necessarily have a consent manager. Law asks you to provide an option to, data principals so that they can manage their consent through consent manager. I don't think that I will read the law, but it's a good question, but it's a difficult one, that you must necessarily have a consent, I mean, third party consent manager on board, on whether you can do, in-house. But to the extent, if in-house capacities, because my understanding is that doing it based on with so many clients now, doing all of this in-house may be very tricky. Uh, you know, at the end of the day, you're looking at a system where everything is automated, and for all companies to do in-house is going to add to a lot of cost and a lot of internal time and resources to do that. So it may be good to do it through a consent manager. I would suggest.
I sort of agree, but again, it's a question of cost benefit versus practical nuances which you'll have to take. And it is not mandatory as the language given by the law. It's purely a call which you can go ahead and take it. Okay, Sarika is also asking what happens to international airlines. Bear in mind, the moment you're processing for rendering certain services in India, I think the de facto rule is that it is applicable. Not sure how many of them are aware. Some airlines also have, Indian Airlines also asks for GDPR or equivalent privacy law compliance when you are registering or onboarding or about to travel. I remember certain countries where I was visiting, they had taken a consent from me that I'm processing under the laws of XYZ, right? Singapore, Malaysia, Japan, whatever it is, they are processing it under those laws as well. So just for you to be aware of that. And is there any compliance checklist? Parth, do you have a compliance checklist handy?
And, it cannot be a compliance checklist in the sense that, yes, we are preparing documents and a standard set of RFIs, request for information or questions, to do the gap assessment. A gap assessment is nothing but essentially it is, uh, an assessment of the data flow in your company, from which point sources data is flowing, what kind of data is flowing, and then to see that how are you processing that data. Are you processing that data with some consent management in place, or how is it being processed? And that gives us an idea that where do you stand in terms of the requirements under the DPDP law as of today. So that's what we call gap assessment. So there is a list of questions which we ask. Then there are a list of set of policy documents which you should ideally have in your company, on breach policy, data retention and erasure policy. You should have an employment employer employment data policy as well. There are a host of policies which you need within your company. So I can't really say there is a compliance checklist, but yes, I think much of what Nara said today about the obligations of DF is actually a compliance checklist in many ways, that you need to comply with all these obligations. Particularly, Section 8 of the Act is very, very important for you. But happy to answer if there is any specific question on compliance.
Got it. We are an AMC, so there's a lot of trading restrictions. We ask for disclosure of investments in personal trading account to protect conflict of interest and prevent insider trading. We can't ask our employees to revoke consent in this case. Will this be considered a legitimate use? Sudhanshu is asking this question. A very peculiar and in-depth. Uh, to me, unlike the GDPR, let me be very honest here, the legitimate use cases are very, very specific and defined. The GDPR gives you some bit of an interpretation oriented provision, which is not there in the DPDP. So legitimate use cases are specific things, and some of them were already discussed during the conversation. So if it does not fall under specific use case or the legitimate use case, the best thing you could do is ensure it is updated in your notice and you go ahead and take the approvals or consent based on that. Um, okay. Just seeing if there's any interesting questions in because we have slightly short of time. Picking up.
So there is a question, Nara.
Uh-huh.
It's asked by Anonymous. We are a software company and our application is on a SaaS model. Our clients collect personal data and the same is processed on our software. What is our obligations under the
Good
Act?
question. Good question. So if you're a SaaS company, first and foremost is you would have one set of personal data that is purely where you are deciding the means and purpose. It could be your customers, it could be you attending some conferences, some SaaS meetings, all of those, and you are collecting that. That is the first requirement as far as that information is concerned, and as far as your HR information is concerned, you would be a data fiduciary. Now, as far as your customer's data is concerned, your customer decides what personal information has to be stored, etc. And therefore, you are a processor to that extent. It's another matter that you as a processor may need to have much more stringent controls, including data masking, obfuscation, etc. So that you would be following the principles and your product becomes a better fit for your customers to consume. So you can say my product is privacy ready or privacy compliant ready. So that's basically how I look into it, because a lot of SaaS companies are today facing this challenge. And in fact, when GDPR and HIPAA and the global regulations came in, we did a lot of work on this, where we had to change the architecture in such a way that the product itself is personal data or a personal data privacy law compliant, and this is more to showcase to the end customer, because you as a processor will have to give comfort to the end customer, otherwise the fiduciary will say you are not compliant with data privacy law, so therefore I'm not going to go with your product.
So there's one more very interesting question, Nara, especially that I represent marketing at InCorp. There is a question that says institutions collecting information for educational purposes, including KYC for admissions, etc., fall under legitimate use. But if the same data is used for marketing or other outreach purposes, then the exemption cannot be availed, right?
Uh, you want to go ahead, Nara?
So to me, whether it's educational purposes or not, it really doesn't matter. The law has not given a golden sword saying that, hey, here is the purpose where you can do any amount of personal data processing without any sort of consent. That will defeat the whole purpose of law. The purpose of law is very, very simple. If you want to process personal data for, of course, not for a personal purpose, but of course on a business or a official purpose, ensure that person has given a consent other than those legitimate use cases which have been specifically given by law, right? Now, one could also interpret if there is a requirement under the statute to collect certain things. Now, for example, I am required by the laws of labor that I need to collect Aadhaar number and I need to safeguard that. So you don't need to take a separate consent because that comes by virtue of law, right? On the contrary, for an educational purpose, if KYC is mandated by law, right, which is what is happening in most of the institutions, it is treated as you don't require a separate consent as such, but you would generally go and still draft in your document or your admission document, whatever it is, that I am collecting the following information. But if it is used for any purpose other than that, it is highly recommended that you go ahead and get a consent.
Yeah, and I would just like to add, I think the whole idea and the phraseology of legitimate use is being understood as what people consider legitimate, and that's not the correct approach to understand it. Legitimate use is a bucket which is identified under Section 7 of the Act, and we'll advise very strongly that please go through Section 7 of the Act. If your activity is not falling under Section 7, as Nara was just explaining, there is no exception for educational purposes. Merely because you're running an institute and providing education, there is no exemption, unless central government tomorrow exempts, and that leads to other issue. Until the law comes in force, there are a lot of advocacy opportunities also available to you, because you can go and advocate to the government that certain industries or sectors may get an exemption, because the central government does have power to exempt certain industries. Absent that exemption, you cannot just call something as legitimate because you think it's legitimate. KYC is legitimate, so we'll have to do it. Legitimate use is a very closed bucket, a defined closed bucket as provided under Section 7. If you don't fall under Section 7, it's not legitimate use, which means now you must take consent. And somebody just asked a question that if there is a public information, then what do we do? The public information, as Nara explained at the beginning, information that has been disclosed publicly, that doesn't enjoy protection of DPDP law. Please understand, this is the privacy law. Somebody who has chosen to offer his personal data in public domain, he has waived his right that that information is no more private and then that you can use it. So just pause here.
Interesting. So, Parth, we have one more question from Pradeep. He says he's asking, since we handle client business data and risk profiles, how does the DPDP Act distinguish between business to business data and the personal data of individual stakeholders? And what specific consent mechanisms should be implemented for our consulting agreements?
So I'm not clear about the business, but I'll just, Nara, please feel free to add. Look, business to business information is again not personal data. If so, you are collecting some company's name, it's not an individual's personal data. Name of the company doesn't enjoy protection. The protection under this law is for natural persons. And natural persons mean people like us. All of us are data principals. If you are the one, as Nara said at the very beginning, please always apply these two tests and it will solve many problems. If you are the person who is determining the means through which you collect data and the purpose for collection of data, if you satisfy these two limbs, then you become a data fiduciary. So in your consulting business, if there is flow of personal data of individuals which you are collecting, you are determining the means and purpose of that, then you become a data fiduciary, and then you will have to go through either a consent based mechanism, unless you are able to demonstrate that the way you are collecting and processing data is falling under one of the legitimate use, right? Unlike GDPR law, there is no contractual necessity as a ground for processing data in India. So merely because you're entering into a business contract with someone, and therefore you're fulfilling some obligations under that business contract, therefore you don't need any consent, that will not apply under Indian law. That's why I said that Indian DPDP law is a plus in many cases. We don't have a contractual necessity clause as is in the GDPR. Either processing will be on consent or it has to be a legitimate use. The boundaries of legitimate use are very, very strict. It's a very narrow bucket. Everything else outside that legitimate use falls in the universe of consent. So you'll have to take consent. Company information, business to business information, company information is not something to which digital protection data applies at all.
Okay, interesting. I see there are so many questions still, and we are running short of time. We've crossed our session slot. So what we can do is, are we okay to close the session and we can take up these questions later over emails? You
Yeah,
all
I think
can
that should be
please,
good. Maybe they could
yeah,
write us a note, and if you could just share the
yes.
details, they could share email, and then we could
So
probably.
this clearly shows there's still a lot of confusion, lot of queries with regards to this complex act. And thank you so much, Narsimin and Parsati, for breaking this entire complex act into something very clear, practical, and relatable framework for all of us. And this, as we again, once again, as we are on the World Data Privacy Day, it is a reminder for all of us to understand that compliance is just not a mandate, but it is a question of one's from going from regulation to reputation, and it is something that doesn't happen just in the audits, but is in our everyday task, where how we store, collect, use, share data on daily basis. So I request everyone, you all can follow us on our LinkedIn to get more insights on the DPDP Act and also get updates on our future webinar. Here is the QR code for our LinkedIn link and also the email ID that you can write into us. And Parth and Nara both will be very pleased to respond to your queries, any specific queries that you all might have. All right. Thank you so much, Nara, Parth. Have a lovely
Thank you.
weekend, everyone. Bye
Thank
bye.
you
Thank
very
you.
much.
Take care. Bye.